going to go ahead and get started. I'm just going to go ahead and turn it over to Michelle so she can reintroduce herself and get started with this topic about parenting plans. Thank you.
Yeah, I don't know. We've been doing this for a few years. That's never happened before. But anyway, so yeah, we're here to talk about restrictions in your parenting plan. I'm Michelle Dellino. I am the owner and attorney, one of the attorneys at Dellino Family Law Group. So we're going to talk about restrictions in your plan. Or if you might have a spouse or former spouse or partner that should have restrictions in your parenting plan. So restrictions in a parenting plan are difficult to understand. They're difficult to understand when they're appropriate, when they're warranted, how you get them, why you might not get them. There's a lot of different considerations that you might have. So what I'm going to do is I'm going to talk first, and we're going to allow opportunities for questions as well. Melissa will help field those. I'm going to talk first about what that really means. So Washington state parenting plans, generally, unless there is a basis for restrictions, and that's what we're going to talk about, allow parents to have liberal time with their children under a schedule, allow things like joint decision-making and residential time for both parents. When there are restrictions, Washington courts have a broad discretion in determining a parenting plan in the best interest of the kids. That's the overarching theme, is the best interest of the children. So when there are restrictions in a parenting plan, and that means serious concerns affecting a party's ability to parent a child, the court may, in some instances, the court must, and may and must are really important words to pay attention to. The court may means they have discretion. They can do what they want. The court must means there's no choice and they have to put a restriction in place. So when those restrictions go in place, the court may or must restrict a party's residential time and decision-making authority and future dispute resolution process. So those are the things that can happen when there is a basis for restrictions in a plan. This is all governed by, and I'm mentioning the statute number, not because you need to know it, but because you might hear the term 191 restrictions. Some of you that might be watching might be in the middle of a family case. You may have been through a family case. You may be contemplating a family case, and you might hear the term 191 restrictions. And you might be wondering, what does that even mean? Well, RCW 2609191 is what that refers to. First of all, RCW is a little bit of a crash course, is the Revised Code of Washington. That's the statutory law in the state of Washington for the most part. There's also the Administrative Code, which is a WAC, but this is RCW. RCW Title 26 is a whole bunch of different laws that govern domestic relations law in Washington. So RCW 26 is that chapter, and then the second part is all of the different subsections. So 2609191. So when you hear about 191 restrictions, it's referring to the fact that 2609191 establishes circumstances when the court must consider whether limiting factors exist that affect one or both parties' ability to parent a child. The important thing to know there is both parties could have restrictions against them. I've seen cases where both parties have restrictions. A lot of the time it's just one parent, but whether a ruling on a temporary or final parenting plan or a modification of a parenting plan, the court must not impose restrictions on either parent's time unless there is a finding of a 191 factor. So that's kind of what I said earlier. Unless there is a 191, there's not going to be restrictions or decision-making that's restricted significantly for either parent. So in short, the court maintains broad discretion when ruling on parenting plans, but 191 factors must be considered, and that statute must be considered when serious issues are identified. Anything yet, Melissa, or should I keep going?
We do have a question here.
Go ahead.
Could you talk a little bit about long distance parenting plans? Is it difficult to get permission for a child to spend some periods abroad if a parent has a job assignment abroad, or like a month over summer or school holidays, that kind of thing?
Yeah, I'll talk about long distance plans, but I'm going to go a little bit more about restrictions, then I'm going to come back to that. I think that's probably a good idea. But yeah, because if you have restrictions, you're not getting a long distance plan, or at least not one with ample time. So first, I just want to talk about, before I come back to that, what are limiting factors under 191? You've heard me say they have to exist. So RCW 2609191 requires the court to consider evidence, which includes arrests or convictions related to criminal acts, domestic violence, substance abuse, child abuse, neglect, and abandonment. So the court must evaluate claims that a parent has an impairment that interferes with their ability to parent if one of those things is present. If a parent withholds a child from the other parent for an extended period of time without good cause, the court could also find that as a limiting factor. So here's the following situations that are identified under 2609-191 subsections 1 and 2. And these are limiting factors that this is where the court must impose restrictions. 1, willful abandonment by a parent. So abandonment that continues for an extended period of time or refusal to perform parenting functions. So that would be a parent just like leaves and they are completely out of the area. They don't make contact with the child. That's abandonment. Okay. And you typically need abandonment of like 6 months to a year for something like that. Second, physical, sexual, or a pattern of emotional abuse of a child. If there is a finding of that, the court must impose restrictions. Next, a history of acts of domestic violence or an assault or sexual assault, which causes serious bodily harm or the fear of such harm. So if there's a DV restriction, again, the court must impose restrictions. Finally, a parent has been convicted as an adult of a sex offense under certain statutes. That is mandatory restrictions again. So those are where the court must impose restrictions. Now, that's different than 2609-191 subsection 3. And this is where a parent's involvement or conduct may have an adverse effect on the child's best interest, and the court may implement restrictions. So this is where restrictions aren't mandatory, but they could very well happen. 1, neglect or non-performance of parenting functions. So not abandonment, but just neglect. 2, long-term emotional or physical impairment that interferes with the parent's ability to perform parenting functions. So that could be some kind of that could be some kind of a mental health issue. It could be a physical impairment, but a lot of people have mental health issues. A lot of people have physical impairments, but it actually has to impede that parent's ability to fully function. There needs to be a nexus between that and the actual parenting function. The next is a long-term impairment from drugs, alcohol, or other substance abuse that actually interferes with parenting functions. The next would be absence of substantial emotional ties between the parent and the child. And the next would be abusive use of conflict. This is one that comes up a lot that creates a danger of serious damage to the child's psychological development. Abusive use of conflict is basically creating conflict and driving conflict over basically everything to the point that it is impeding the co-parenting relationship and causing damage to the child. The next is withholding. Like I mentioned earlier, a parent withholds access to a child for a significant period of time with no good reason. And anything else the court finds limits the best interests of the child. So there's a lot of different factors. And next I'm going to talk about what happens when limiting factors are established. But first, I do want to answer that long distance question. Oh, go ahead.
Yeah, there was another question that just asked, where could you find a full list of the restrictions under 191?
You could go to online and just Google RCW 2609-191, and you could read the statute. Okay. And it's not like a list of exhaustive restrictions. You need to understand what the statute means. But if you want to read the statute, that's where you should go. So hopefully that's helpful. The person that asked about long distance parenting plan, I'm not sure if it was long distance travel or long distance parenting plan. In your parenting plan, if one parent doesn't live close to the other, a typical long distance plan will have one parent be the primary parent during most of the school year, and then the other parent will have most of the breaks. They'll have most of the summertime, they'll have probably majority of the winter break, and they'll have like the longer breaks. So it's unfortunate because sometimes then the residential parent feels like, I don't have any vacation time with my child, and you'll be able to have a little bit, but the other parent is going to have as much time as possible. If it's difficult to get a long distance plan, it shouldn't be unless there's restrictions. If there's restrictions, it is going to be difficult. What a long distance plan looks like, though, also depends on the emotional development and age of your child, because a child, for example, might not be able to be away from one parent for the entire summer when they're 4 years old. That's very different than a parent that's like a child that's 13 years old. So developmentally appropriate is definitely key when you're dealing with long distance plans. So I hope that helps. Yeah, you want me to move on, or are there any others?
Just one other question. How would long-term emotional damage be demonstrated, proved, or documented?
That's a good question. And I would say, and I'm going to just put this out there, and this is probably something that everybody doesn't really want to hear, but it's very difficult to document long-term emotional damage. The best I think the best way that you're going to have documentation of that is if your child is in therapy and you have access to, you have support of a therapist, or if your child has a relationship with a school counselor and there is, documented history there. But it's really going to very often be historical information that can be gleaned from records. Because, number one, your child's not going to come into court and testify. And number two, it's very difficult sometimes to have people that actually have personal knowledge of that kind of damage. So sometimes you're going to need an expert opinion on something like that. I mean, it also can be examples, there can be examples of that as well, but fact specific examples, but it's very difficult. I'm not going to tell you otherwise. Anything else?
Not right now.
Okay, perfect. All right, I'm going to go on and talk for just a few minutes about what happens when limiting factors are established. So what'll end up happening? Let's say a court considers the evidence and they impose restrictions on a number of parenting functions. The most common, aside from residential time, is limiting decision making. So that usually will give one parent sole decision making. And that means decisions about education, healthcare, non-emergency medical, extracurriculars. Sometimes some or all of those will be given to one parent if there are limiting factors. It also, another thing that will happen once there are limiting factors is there'll be a waiver of the required dispute resolution process. In your parenting plan, if you and the other parent don't agree about some part of the plan, there's usually a requirement for some kind of dispute resolution in every plan. However, if there's a limiting factor, you don't have to have that and you can go straight to court. So that's actually very important to know. Other ramifications of limiting factors and can include having one parent need to be under supervised residential time or limited residential time. And sometimes those things will be contingent upon a parent being compliant with some kind of treatment or some other I would say some other requirement. Sometimes there might need to be a parenting coach. Sometimes there might need to be any number of things that one parent is doing to be engaged to be able to get either limited visitation or supervised visitation. And supervised visitation can be expensive. Most people don't want to do it. But if it's the only way that you're going to see your child because there's limiting factors, that's going to be the option. So here's a list. I'll give you a little list of things and possible outcomes where the court might find limiting factors. That might be helpful to hear some real world things. If substance abuse has interfered with parenting functions, the court might consider a parent's residential time on successful completion of drug and alcohol treatment and then order ongoing tests. So that could happen. Like if it's a drug and alcohol issue. And then here's another one. If a parent engaged in physical abuse, the court must grant sole decision-making authority to the other parent, and the court must limit the abuse of parent's residential time. So if there's a finding that you abused your child or the other party did, you're not going to have decision-making and your time is going to be limited, and there's no way around that. If the court finds one parent has a history of domestic violence, the court must grant sole decision-making to the other party and may require supervised residential time, but only after completion of a DV program. And that's another very common scenario is having, somebody has a history of domestic violence, they have to complete treatment and they will get no decision making because that's just what it is when there's a DV finding, that's the law. Next would be like, if a parent is a convicted sex offender, the court almost always has to prohibit that parent from having time with the child. So that's one of the rare exceptions to saying, almost everybody at least gets supervised time. If a parent is a sex offender, they are probably not going to get time. Here's another one that comes up a lot. If a parent has withheld a child from the other parent for an extended period of time with no good cause, no reason to, the court may limit and impose restrictions on the offending parent's time. So that would be like mom doesn't allow dad to see the child. There's really no reason. It's not like they're protecting the child from dad. There's not like anything they have to do. You might end up in a situation where then dad eventually goes to enforce the parenting plan or establish a parenting plan, and mom is found to have been withholding in that kind of an instance. Mom, it's not going to look good for mom. So mom is engaging in what's called gatekeeping with no good cause, and that can end up in restrictions for her, or it could be dad doing it to mom or whatever it might be. That's just an example. If a parent engages in abusive use of conflict, that usually pertains to decision making. And if you have been found to be having abusive use of conflict issues, and there's actually a finding, sole decision making is likely going to go to the other parent. I mean, if you really think that limitations and restrictions will be an issue in your child custody determination, you should really talk to an attorney, because once there are restrictions against you, it's very difficult to ever change that. It's almost impossible. If you believe there should be restrictions against the other parent, you want to make sure that you get those restrictions and you don't foreclose the possibility, because if you do, coming back and saying later, oh, wait, this should have been a restriction, that's like literally not going to work. So I can also talk about a variety of other things with respect to restrictions, but I think what would be really helpful for people to know is to kind of think about how that works in the life cycle of a family case. But before I do that, Melissa, is there anything else? I think I see questions.
Yeah, we have a handful of questions. Okay, I'll ask this one. This is a situation where a child was, open with teachers and counselors at school, and told them not to say anything to their primary parent due to safety, but they needed to inform the primary parent. Now the kid doesn't want to talk to anybody anymore, but the other parent is saying they need to see behavioral health. So what do we do in a situation where, you need your kid to see behavioral health, but the kid doesn't want to go because of fear of retaliation from the parent who's primary?
So the kid doesn't want to get the help. I mean,
the kid is scared of, their own safety, I suppose, with the primary parent if they are open with mental health or behavioral health.
I mean, that's really, really, really tough. I think a lot of it too depends on how old your child is, because it can be pretty difficult to, this happens a lot with what we call refusal cases, where it can be difficult for teenage kids to force them to see a parent they don't want to see. And it could also, it'd be very difficult to force kids to engage in health or counseling when they don't want to. That is very, very difficult. So I don't really have an answer for you, because it's kind of a fact specific situation. If a child doesn't want to open up, like we've even had situations where kids are ordered to go to some kind of reunification therapy with a parent or whatever, or go to, child goes to therapy. If they don't want to talk, they're not going to talk, and that's just really difficult. So I think making kids feel safe the best that you can, and offering assurance to that child, that it's a safe space for them, is important. And especially if they're at a certain age, I mean, they have, there's confidentiality over their own medical situation and their own sessions. Melissa could talk about that probably, even if there's parents. So, it might be safer for them than they think, depending on how old they are.
Yeah, if your kids are teenagers, it's a different story. But if they're younger kids, then that's a different situation. And I think they are, because the school had to inform the parent before.
Oh yeah, probably so.
So it's a tough one. It's a definitely tough one. It's a very case specific situation. I, recommend maybe you as the even the non-primary parent talk a little bit to the counselors that are involved, try to figure out what they recommend in a situation like this.
Yeah, that's true.
We've got a bunch of other questions, so I'm going to try to tackle a few. I just want to make a note. I'm going to have to not ask the questions that are really case specific, and focus on the questions that are a little bit more general. So question here is it common for a party to request a psychological evaluation for both parties as a part of a divorce case with a child, or do you first need to show that there's strong parenting concerns to request such a thing?
I mean, you can request it, and this is what I would, you can ask the other parent if they'll agree. I would almost always, unless there's a really serious concern, I would almost always just ask if one parent wants it. I would usually say, hey, my client's willing to do it. Are you willing to do it? If you think it's not something where the court would necessarily order it, it makes sense to ask the other party first and just see if both people are willing to do it, to give one another peace of mind. But a court's probably not going to order a psych eval unless there's something really serious that's already happened, or unless you get a guardian ad litem who's going to do an evaluation, and then they make a recommendation asking the parents to get evaluated, or a parenting evaluation. Parenting evaluation will have a psychological testing component. So it really depends on the specifics of your situation. I would never say it's like common to get a psych eval. I think if you want one and you think the other party is going to be willing and you're willing to do it, sometimes that can be something people can do, but the court's not going to order it unless there is a reason.
And can you say anything about what is considered physical abuse, in the court, in the eyes of the court, light spanking, to correct behavioral issues? Is that,
No.
fall into that
You can,
category?
the Washington Administrative Code, I mentioned the WACs earlier, talk about corporal punishment. I'll tell you this. Parents can discipline their children, and in Washington, you can spank your child and engage in physical discipline as long as you don't leave permanent marks, and as long as it is, again, like a light spanking to correct a child's behavior is not going to be seen as physical abuse. However, let me put this out there for you, and I'm going to just be very honest with you. Courts, especially in King County, are not fans of corporal punishment. You have a right to physically discipline your child, but I'm telling you now that if one parent goes to the court and says, you know, I'm asking for restriction on corporal punishment by either parent, these are my concerns, the court's probably going to give it to them and put that in your plan that neither parent will engage in that. I've seen that happen time and again. So, there is definitely a trend away from physical discipline of your children. That's very different, though, than physical assault. If you punch your child, hit your child, do anything that, you know, is not corrective behavior that leaves more than a transitory mark, that's physical discipline. So that's very different than a spanking. But I would just caution you that if spanking becomes an issue and one parent really doesn't like it, court's probably going to side with that parent and put a restriction on it, just at least on a temporary basis.
Any differences in Snohomish County?
Maybe.
Mhm.
I would say King, Pierce, and Snohomish are all sort of trending that way. So yeah, corporal punishment is not as common, I think, as it once was. I'm not passing any judgment on that. I'm just telling you what I've seen. So
Okay. A couple of questions of the same here. At what age does a child say matter in a parenting plan determination? Another question is same question, really. At what age
I
can a
like
kid?
that question because the answer is never.
Mhm.
It's a very easy question. What a child wants, and there's a practical application of that, though, what I just talked about too with teenage kids. So never. Some people will be in certain states, oh, when a kid's 13, they get to say where they want to live. In Washington, the answer to that is never. Your child will never be asked where they want to live by the court. That will never be a decision-making factor that the court will say, at a certain age, this kid got to make a decision. Never. And the reason why is that Washington courts don't believe that children should be put in the middle or to have to make that kind of decision. And the children should basically not be put in the middle of that kind of conflict. And however, there's another side to that. If you have a child that's not 5 and they're 15, for example, or they're old enough to be able to have an emotional maturity about them to make it known what they want. And the reason that this matters on age is when a child is 5, if they get a lot of candy and they get to watch a bunch of TV at one parent's house, they're probably going to want to be at that parent's house. It doesn't necessarily mean that that's like where they should be, right? And they also can't self-report as well. They can't talk necessarily as well and be reliable narrators about what's going on in the home the way that a 12-year-old could. So if you have a custody evaluation by a guardian ad litem or a parenting evaluator or family court services or CASA, anybody that's doing a parenting evaluation in your case, they're going to talk to your children. And the opinion and the thoughts of a child who is older and able to be a reliable narrator, as opposed to a very young child, there's going to be a lot of weight given to that. It's not going to be the determining factor, but it's going to be in the evaluation of this is what the kid said. And courts are going to give that component of the evaluation significant amount of weight because it's a child that's old enough to know better. Sometimes, though, you might have a child that is a teenager and they want to be able to go out and they want to be able to date and they want to have a phone and they want to do all this stuff. And there maybe are siding with the parent that's going to give them that. Well, that doesn't mean that like the court's going to be like, yeah, that's a great idea. But it does mean that when your child is older and they can voice concerns to an evaluator, because that's the only way their voice is going to come into court. A child's not going to come into court and ever testify. It's going to be through an evaluation. And if a child is of a suitable age and discretion to be able to make those kinds of comments, then it's very likely that some of that's going to be given some weight. But there's no magic age and they never get to make the choice. So I hope that helps.
Yeah, definitely. Okay, there's a ton of questions, so we're going to do the
All right.
best we can to answer
Talked a
some.
lot about restrictions, so I'll answer a few more questions. That sounds good.
Yeah. If a parent makes accusations of the other parent being mentally unstable, how best to protect witness testimonials or what?
Say that again.
if a parent is making accusations of the other parent being mentally unstable, I think the question is how best can the accused parent protect themselves? Witness testimonials, how do they show that they are not mentally unstable?
Well, eh, witness testimonials is not helpful. Let me tell you this. You have people come in and be like, my friend's not unstable. My sister's not unstable. These are the things. Number one, the court doesn't care. Like of course, you're going to have people come in that are going to say good things about you. You want people, if you're ever, this is just a general witness statement or statement about declarations. You want people, that are going to be able to talk about relevant information that they personally observed, not what someone told them, not what they think, not what they saw you do 5 years ago. Recent relevant information about your parenting or something like that is generally helpful. Otherwise, the court doesn't really want to hear from everybody that you knew, and it's not relevant. If someone is saying you're unstable, well, what are they saying? Are they saying your behavior? Are they giving specific examples? Because then you want to look at what examples they're giving and then see if you have other people that personally observe what really happened, or if you can say what really happened because you were there. If it's just like, oh, this person has a demonstrated mental health history, a lot of people do. A lot of people are in therapy. A lot of people take, antidepressants or SSRIs of some kind. There's nothing wrong with that. There has to actually be, I mean, that's most people. That's like actually taking care of your mental health. There needs to be a nexus, though, between some kind of mental illness and the inability to parent, which is what I was talking about with restrictions. Anybody can have a drinking problem, have a mental health problem, and it doesn't, if there's not a nexus or connection to how it affects the parenting, it doesn't matter. You know what I mean? So how you can defend yourself too. I mean, if push comes to shove, you can get a mental health evaluation or a psych evaluation, or if there's a custody evaluation done, then the guardian ad litem is going to talk to you, and they're going to talk to collateral contacts that know you. They're going to talk to your therapist, and they're going to get information. So you really, how you answer something like that depends on the fact specific allegations being made, and then the context of the case. I hope that helps.
Yeah, thank you. Okay, another question. How do judges feel about restoring first right of refusal when a commissioner assigned no first right of refusal without either parent requesting? I guess one
Okay.
parent loves, the other parent
I
doesn't.
say this like the nicest way. Right of first refusal is a waste of time and it sucks and the courts hate it. So probably
People
not.
don't know what that means. Maybe you could tell
Yeah,
them.
and I'll explain what it means. Yeah, so probably not is what I'm going to say. Most family law attorneys, mediators, and judges don't like it. What it means is this, and some people will call it right of first refusal. Some people will call it first right of refusal. They're interchangeable. It's the same thing. It means if a parent is not able to exercise their residential time with the child, they have to offer that time to the other parent before they can get other child care. Sounds great, right? It's not. It's very often used as a controlling provision. You have to tell, and it also allows one parent to have to know when you're going to be somewhere or not be able to have your kids. And it's a very hard thing to prove. Like, well, how do you, it's not favored. It's different if you have very young children, you live very close together, it might make sense. Or if you really get along really well, it might make sense. But then you don't really need the provision because you would just offer it to the other parent. But bottom line is, if you're going to have a first right of refusal in your parenting plan, I believe, and the only time I really see courts doing it anymore in most circumstances, is if it's for a longer period of time, like an overnight. Okay, if I'm going to be away overnight, I'm going to offer it to the other parent before we have to get childcare, But if it's like for any reason, no, that allows it to be a complete control provision. Even 2 hours, 4 hours, no. I mean, then you couldn't even go to the store or do shopping or go to a movie without asking the other parent. That's pretty ridiculous. 8 hours, like a whole day, maybe. But I mean, sometimes people have to work an extra day. So what? They have to ask the other parent? No. I mean, most of the time an overnight at best, but if a commissioner took that out of your plan and didn't award it, I think you're going to be very hard pressed to get it in a final plan, unless you have a recommendation from a guardian ad litem or parenting evaluator giving a specific reason as to why that's appropriate.
Thank you. Okay, lots of more questions. We'll get through what we can here.
Yeah.
How to restrict an international abduction of a U.S. citizen, 7-year-old kid, especially when the other country is not part of the Hague Convention?
How to restrict it? I mean, you should have something in your parenting plan saying that the parties won't agree to travel to non-Hague Convention countries. That's pretty normal, and that's pretty. You probably won't have a hard time getting a court to agree with that, unless there's a reason. I did have had clients before with family members in Russia or whatever, And in those kind of situations, but, you know, in those kind of situations, you might be able to get some kind of provision so children can still see family, but it's not unlikely that a court would agree with you to restrict travel to non-Hague Convention countries. And for anybody that doesn't know, Hague Convention, most countries, many countries like Western Europe and Canada and, you know, are signers to the Hague Convention Treaty, which basically says your parenting plan will be enforced. So let's say a parent goes to Germany and does it for vacation, just decides I'm never coming back. Well, in Germany, your parenting plan is going to be enforced and that kid's going to be brought back. If you go to India, that's not going to happen and you might never see your kid again. So that's that's the example, the difference of an example between a Hague Convention country and a non-Hague Convention country.
Thank you. Can you talk about the differences between joint custody and full custody, especially in a long distance plan where a kid lives with one parent mostly during the school year and then comes and visits the other during the holidays? Should it be custody, or what is that? What are the differences in the
Joint
word?
custody is not really a term. There's two kinds of custody in Washington: physical custody and legal custody. Physical custody is who has the child at the time. So if I have a parenting plan and child's with me most of the time, I have physical custody. If they're with that other parent in the summer, that parent has physical custody. Legal custody, and I'll talk about primary custody in a minute too. Legal custody, but these are the two things you need to know. Physical, who has the child. Legal custody is who can make decisions for a child and who's a legal parent. So even if you don't have the child the majority of the time, because the child lives in a different state than you're still a legal parent. You still have a right to get their school information, their medical information, to make decisions for them. You're still their parent. Legally, even if they're not with you physically all the time. Then when we talk about primary custody. So primary parent status is the person who has the child more nights, who has the child most of the time. So if it's a long distance plan and the child lives in Seattle, 90% of the time, and they live in Colorado 10% of the time, summers and whatever, or usually more than 10%. But the primary parent is the person who has more nights. So, I mean, some people say that's primary custody. There's no sole custody unless the other person really has no time and no decision making. Otherwise, you have some kind of fusion of physical custody and legal custody. I hope that helps.
All right. I'm not sure what this means, but maybe you do. How often do you see the silver bullet approach in King County parenting cases?
I don't know what that means.
Okay, neither do I. We'll move on. Okay.
If I don't know what that means, then a lot of people don't know what that means.
Do courts care if the other parent doesn't allow you to have a video call with the child over Christmas? In this case, the child was 3 years old with the other parent for a week. The courts care. I mean, I suppose if it's as part of the plan, right?
Yeah, I mean, if it's not in your parenting plan, you're not obligated to video call with the other parent.
Yeah.
Mm-hmm.
Okay. Can you give examples of what the court might see as unwillingness to co-parent?
I mean, no, that's going to depend. Like, if you have a parenting plan in place and you have, I guess here's an example. If you had a good parenting plan will have a process for joint decision making and a time that another parent has to respond by. So if it's like, hey, I want to sign Johnny up for soccer, do you agree? The other parent just like ghosts you and doesn't respond. So then you don't know if you can sign Johnny up for soccer, and then Johnny doesn't get registered and then he misses the time. Court's not going to love that. But a good plan should basically say, if one parent doesn't respond within 72 hours or whatever, it's assumed that that parent can go ahead with the decision. So then it's a non-issue. I mean, co-parenting, okay, I have a case that's been going on off and on since 2017. First, it was a divorce, then it was a modification, then it was another modification. These people constantly have problems. And I would say that it has been established that they cannot co-parent because they cannot make decisions together. So now one parent has sole decision making. And there's just constant issues. And maybe one parent's communication to the other parent is abusive and is not relevant. And that is a situation where someone is being abusive with their communication and not co-parenting, but refusing to co-parent. Some people, this happens. It'd be great if everybody got along and could make decisions for their kids together and could really align. And if you had a co-parenting relationship where you could sit down every quarter and over coffee with your co-parent and talk about what your kids are doing, that'd be great. That is not 90% of most cases. A lot of the time, one parent will want to have a lot more contact with the other parent and be a lot more involved in what's going on and, your kids. And one parent really just wants almost nothing to do with the other. And that's as long as it's not impeding your kid's development or you're not refusing to share information, that's okay. And a court's not going to force you to have more communication with that other parent. That's something that comes up a lot. But anyway, it's a pretty fact-specific situation.
Yeah. And a number of these are, so I'm trying to sift through what we can ask here. Is legal custody restricted by a DV finding? Is that part of the restrictions?
Yeah. Decision making. Yeah. If there's a finding of DV, there's no it'll be sole decision making for one parent. You're still a legal parent. You still have right to get information, but your decision making will be impeded, and your physical custody will be impeded because it's a basis for restricting your time with the child.
Does the court approve if it's not your week that you cannot go to sports or extracurricular activities or practices or tournaments?
No, I mean, not unless it's specifically, sometimes in a parenting plan where there's a DV or restraining order or some other high conflict situation, it might specify on your plan that a child will only, if there's an order in place where the parents can't see each other or something, it might be then that the parent whose time it is will go to the activity. Usually the parent whose time it is will take the child to the activity and go, the other parent can go. There's no reason, and no one can restrict you from going to your child's activities or being present at school. You might not be able to take the child because it's not your time, but you can go unless there's some other reason or other order that keeps you from being able to do that.
Right. Like if there's some sort of restraining order between.
Yeah, if there's a protection order, both parents can't be there, and then it would typically be the parent whose residential time it is gets to be there.
Okay. This is an interesting one. How can I spot or identify emotional abuse toward my preschool kid? What can I do to protect him? I know he spends time with his other parent. And the other parent was highly abusive emotionally toward me, never physically. And I see a lot of behavioral changes when he comes from visits. I just want to just kind of chime in on that one for a minute. From a therapeutic perspective, it's going to be pretty hard for you to spot those things. There's probably going to be behavioral changes when they come from their other parent's house. And it's fair to be concerned, given that you lived through your own, abusive situation with the other parent. But that doesn't necessarily translate. And it's really hard to know in preschool kids who are potentially, struggling with changes and, having to deal with transitions and things like that. My recommendation would be to get your kid in counseling. Even play therapy is really useful for young children, and especially if they're struggling a little bit with the changes of being in two parents' houses. And if you do have concerns, just to have, so you can have a professional support your kid, and then also potentially help, determine if there's actually anything to be concerned about.
Yeah.
Yeah. Okay. Okay, back to the first right of refusal question. One other thing, are you recommending that it's not part of a parenting plan in general, or would it be appropriate if it's for like limited to overnights or longer periods of time?
I mean, I'm not recommending anything because I don't know your situation. I'm telling you, in general, I don't like it. I don't encourage it for my clients because I've never actually seen it go well in 15 years. And so I don't like it, but I'm not saying anything on your situation. I think in limited situations, it might work for you. If you're going to do it, my recommendation for most people in their situations is that it's overnight or a longer period of time.
Okay, totally different question. Can we talk about how we decide the date of separation? For example, if we're under negotiation and reconciliation based on family and friends intervention, but then, okay, this is 2 case specific. How do we prove or decide date of separation? Related to the day of filing divorce, or is it from, how, I don't know. There's lots of specific things here. So just maybe.
Yeah, I'll tell you what, date of separation, this really matters in a divorce case, not like it's really a divorce case question, not parenting plan mod or anything else. And that can be, it's difficult. Here's an example. Parent A moves out, we're like, it's over, it's done. And then you guys go back to counseling and you're trying to work out the relationship. And then you decide later, okay, it's not going to work out. The date of separation is going to be after the counseling and you decided it wasn't going to work out because you were still working on the relationship, not when the person moved out. However, it's very different. You could also live in the same house and someone could send a message to the other person and say, hey, I'm done. I'm moving to the bedroom downstairs. That could be your date of separation, even though you're still in the same house. I had a case once where Person moved out, they didn't file for divorce for 14 years. That was a mess, by the way. Don't do that. Make your case a lot more difficult on the asset side of things. So, I mean, it depends. It's a pretty fact specific situation, but just in general, since someone was talking about reconciliation therapy, if you go to therapy and you're working on the marriage is not defunct at that time. So it's usually after you've decided therapy's not working, regardless of where you live. Hope that helps.
Yeah, thank you. Somebody's asking what I meant by play therapy or at what age that would be advised. Play therapy can be as early as preschool and appropriate all the way probably up till somewhere around 12 or 13. It's just another way of approaching therapy with children. Your preschool and first grade kids aren't going to be sitting and engaging in, more classic type of therapy with their counselor, and probably not even your 11 or 12-year-old will be doing that. It's just a different way of engaging with children from a therapeutic model. So yeah, definitely even as early as preschool.
Okay.
What else here? Is too young? I would engage with a play therapist and ask them. Probably depends on your kiddo. Some 2-year-olds are in preschool, so it might be appropriate. Okay. Is it worth trying to get a parenting plan changed that's 14 years old with 191 restrictions if the other parent does not participate in parenting?
Well, I mean, if it has 191 restrictions, like, I don't know, if you're trying to remove them, you're probably not gonna be able to do that. I don't know what you're trying to change. So, I mean, you have to change your parenting plan. You could watch my webinar on this because there's a whole topic. Modifications. To modify a parenting plan, you need to have a substantial change in circumstances that gives you basis for adequate cause to change that plan, and that's a high bar. So you can't just change it because a lot of time's gone by. If a parent is like completely checked out and abandoned a child, that's a different situation. So you probably would have adequate cause there. But I don't know if you have 191s, you're trying to remove them, that's probably not going to happen.
I think it's more like they have this plan, but this other parent's not participating at all. Like, would you go toward removing their rights or
You can't
just
remove, I mean, why would you do anything if they're not participating? You don't need to do anything. You already have the child 100% of the time. So,
let's see, what to do if there's a mutual restraining order to not disturb the peace, and now the other party reached out to talk about divorce and parenting. Is it risky to meet in a public place?
a do not disturb order is not like a do not contact order. Do not disturb means don't contact me for any unlawful purpose, don't harass me. But if a parent reaches out and it's just like, hey, I want to talk about co-parenting, that's not violating a do not disturb order.
Mhm. Okay, lots of questions here.
Yeah,
Okay,
a little bit of time. I'll take a few more.
there are confessions of DV in the deposition that are within the statute of limitations. If I move forward with the criminal charges in King County, this is really specific. Will the Superior Court judge overseeing that case be the judge assigned for the criminal charges?
No, I'll just tell you this. I can't answer your question. You need to get
Yeah.
a consultation, but I can tell you this. A criminal charge is going to be heard by a different court and judge than a family case. Your family case will be heard on a lower level, like for temporary orders or something, by a family court commissioner. Then you'll have a trial judge who is a superior court judge that's assigned to a family law case. If the other party is charged with a crime, they may be charged in King County District Court. If they're charged with a felony, they may be charged in King County Superior Court. But if they are in front of a judge in King County Superior Court, even though your family case is in front of Superior Court, they're going to be different judges. I hope that helps.
Yeah, thank you. The other parent's taking videos of me during the kid exchange without permission. Is that usual? Is that legal? In the door of my home?
Um, I would say, let's say, it's not abnormal. A lot of times people will do that. Washington is a two-party consent to record state. So if there's an expectation of privacy, you have to have permission to record. If you're out in the public or out in the open, I mean, sometimes people record exchanges. I don't know what to tell you. I wish they could say that wasn't common.
Yeah, yeah. Okay, here's another one. If interstate or international travel is not mentioned in the parenting plan, but one parent is not okay with the child traveling with the other parent across state lines or into another country, is there anything preventing this or keeping them from taking them out of the state or country if it's not restricted in
If
the
you
parent?
don't have it in your parenting plan that you can't travel out of state, they can take the kid wherever they want. So you should have put that in your parenting plan. For international travel, you generally need a travel consent letter and you generally need the parents to cooperate on a passport. So that could limit the situation maybe a little bit. But you should have those things in your parenting plan. Any decent parenting plan should have those things.
Okay. Um,
could also seek a minor modification to add them potentially, but anyway, that's
Yeah.
another topic.
Well, I think they're saying that there's nothing in there. They want to be able to travel, so shouldn't they be able
Yeah, they
to?
should be able to travel. I mean, you might have a trouble with international travel if you don't have permission from the other parent, like a
Yeah.
travel consent, but out of state, they can't do anything about it.
Yeah, yeah. Okay, if one parent's on probation due to DV and there are restrictions on them in the temporary parenting plan because of it, what happens when the probationary period is over? Are these continued restrictions easy to establish for the final plan?
Yeah, I mean, if they have a finding of DV, that's going to necessitate restrictions in the final plan under 191. So, I mean, whatever probationary period they're under, it depends, I guess, on what the ultimate outcome is. If there's a finding of DV, that's not going to change no matter what the disposition of their criminal case is.
Okay. If you have sole legal custody, can you get a child a passport without the other parent?
If you truly have sole legal custody, yeah, where the other parent has no decision making and no rights to the child, yeah, that's usually not the case, but yeah.
Okay.
You also can have, yeah, anyway, I'll leave it at that.
Okay. And then related to the audio recordings earlier, could that be, could those be used as evidence in court?
Maybe, depends on if they're admissible, depends on if there was an expectation of privacy and they had to get your consent, if they didn't have to get your consent, or if it was like a Ring camera or something, yeah, those can be used.
Yeah. So we managed to clear the questions, which is great.
Good.
I didn't ask some of the ones that were extremely detailed and case specific, but we were able to tackle quite a few today. Any last words, Michelle?
Yeah, I mean, thanks for coming. Thanks for listening. Hopefully you got a good overview of what 191 restrictions are and what they are not. If you have questions moving forward, feel free to reach out or talk to any family law attorney. What I would say too is anything that is very fact specific, be careful what you find online or try to glean from a webinar like this. You're well served by getting advice that's narrowly tailored to your situation. I tell people this all the time, and it doesn't just pertain to restrictions, it pertains to anything. Everybody is really well-meaning when you're going through a divorce or custody case. They want to tell you what happened in their case. They want to tell you what happened in their brother's, sister's, friend's case. They want to tell you whatever. And then you can kind of be like, well, why isn't that happening in my case? Or what's going on in my case? And one thing you need to know is divorce is a marathon, it's not a sprint. Custody cases are a marathon, not a sprint. No two cases are alike. And even though people mean well and try to give you guidance, best thing you can do is get individual guidance tailored to your own situation, and also realize that the fastest resolution is usually not the best. You need to take the time, do your due diligence, get information, whether that's for a custody battle or the financial part of your case, and really plan for the best outcome. So I hope that helps. Thanks for coming today and take good care. We'll see you next time.
Thanks, everybody. We'll see you next time.